Good morning, Your Honors, whenever you're ready. May it please the Court. My name is Shana Thorpe of Thorpe & Thorpe, PA, and I am here today on behalf of the appellant, Thurman Goodman Jr. Before I begin, I would like to reserve 5 minutes for rebuttal.
Okay.
On March 31st, 2016, Mr. Goodman was violently beaten by a coworker and assistant manager, both of whom worked for the Liability, Florida Pop LLC. On the eve of trial, Mr. Goodman was denied his constitutional right to a trial by jury because the circuit court granted summary judgment for Florida Pop LLC despite a total lack of summary judgment evidence. This case should be reversed and remanded without delay. There are two fundamental reasons the case should be reversed. One, the motion was not supported by any summary judgment evidence, and two, Florida Pop had a duty to Mr. Goodman. The March 14, 2018 order granting summary judgment must be reversed because Florida Pop did not satisfy any part of the applicable Florida Rule of Civil Procedure. Specifically, Florida Rule of Civil Procedure 1.510 subsection C addresses summary judgment and the requirements therefore. There are three generalized requirements. The first is that the motion must state with particularity the grounds upon which it is based and the substantial matters of law to be argued. The second is that the motion must specifically identify any affidavits, answers to interrogatories, admissions, depositions, and other materials as would be admissible in evidence, otherwise called summary judgment evidence.
Am I correct that they just relied on the allegations in your complaint?
They did, Your Honor, and that was only done at the hearing on summary judgment. It was not stated in the actual motion.
Okay.
The third issue is that the movement must serve the motion and the exhibits thereto at least 20 days before the time fixed for hearing. Since there was no summary judgment evidence submitted, clearly it was not submitted at least 20 days before the hearing. This court has held that it is a reversible error to enter summary judgment on a ground not raised with particularity in the motion. I would draw the court's attention specifically to an opinion issued last year in Ambrosio v. McGuire, 2018 Westlaw 2169848. That case is cited in the initial brief here. In that case, this court held that the generalized representation of the the movement for summary judgment in that case was insufficient. In that case specifically, the individual had indicated that the motion for summary judgment should be granted because there were no issues in material issues of fact in dispute, just a generalized statement, and the only support was a generalized reference to the pleadings in that case, not a paragraph, not a deposition, not an affidavit. And this court held that that was reversible error and specifically sent it back, stating that it would otherwise contravene the plain and ordinary meaning of Rule 1.510C, which requires particularity and not generality, its polar opposite. So in this case, the motion for summary judgment did not even identify the 5 counts of the claim or how the singular case cited applied to those counts. Assistant Manager Travis Green's name does not even appear in the motion, even though 2 of the 5 counts pertain specifically to him. Travis Green is the individual who was also participating in the violent beating of Mr. Goodman. The burden on summary judgment is squarely on the movement in this case, as in every case, and the merest possibility of the existence of a genuine issue of material fact precludes the entry of summary judgment, as stated in the estate of Naomi Gibbons v. Bon Secours at 928 Southern 2nd, 1272, at page 1274, and that's out of this court in 2006. The non-moving party critically does not even have to put on a rebuttal if the moving party does not satisfy its burden first. So even though in this case, Mr. Goodman did submit a declaration as well as 2 separate deposition transcripts, including a corporate representative's transcript, that was not even required because there was no summary judgment evidence submitted by the movement, and thus the movement could not be granted summary judgment under the standards used by the state. Furthermore, under the rules for summary judgment concerning specificity and evidence that would be considered summary judgment evidence, unsworn pleadings are not admissible. That has been held repeatedly in courts, such as Eco Tradition LLC versus Pennzoil Quaker State.
Isn't there a distinction between for instance, if you wanted to come in and move for summary judgment and rely on the unsworn complaint, your own allegations, that would be a problem. But if the defendant comes in and said, okay, let's accept all of the plaintiff's allegations in their complaint as true. Let's accept that as true. We don't have a duty. Isn't there a distinction there?
There is, and I believe what Your Honor is referring to is something along the lines of an admission by a party opponent type hearsay exemption, and that would normally be the case, but that's not what is said here in terms of summary judgment evidence. It has to be admissible in evidence at trial, for example. So normally one can impeach with a complaint, but one can't simply admit the complaint. And that has routinely been used in court. So, for example, in that eco-tradition case I was referring to at 137 Southern 2nd, 495, it says specifically, Pennzoil failed to present any evidence, and goes on, including affidavits, depositions, or documents establishing the validity of the mortgage and notes. Accordingly, it was error for the trial judge to rely solely on Pennzoil's unsworn second amended complaint and unauthenticated attachments. So again, I understand Your Honor's point concerning the admission against the party opponent, but that was not even raised in the motion for summary judgment. Again, it was something that was brought up during the course of the motion for summary judgment hearing, and something that this court squarely shot down in the Ambrosio court case. The whole idea of Rule 1.510C is to provide notice to the non-moving party as to what specifically is being presented as summary judgment evidence, because that burden is so high. And so when a non-moving party is not even aware of a moving party's interest in using the complaint as an admission.
I think their motion for summary judgment specifically referenced the complaint. It said, according to their complaint, Lismore assaulted and injured Goodman in a 7-Eleven store business premises in which neither of them was employed. And that's their whole argument. That's their whole factual basis for their argument.
So are you saying at best this should have been the granting of a motion to dismiss with leave to amend or something like that?
Perhaps it should have been a motion to dismiss at the initial pleading stage, perhaps, but that was not raised. It is something I did address in the reply brief here, because that is something that was raised on the response brief. So yes, hypothetically, the issue of duty could be addressed in a motion to dismiss, but instead of raising that argument, it was not raised, and instead an answer was filed. So Your Honor is correct. That would have been one approach to assessing the duty. But again, I return to Your Honor's point concerning a generalized reference to the complaint. And again, Rule 1.510C specifically prohibits a generalization. It requires particularity and specificity so that both...
I guess my concern is I'm not understanding why that's not specific when it says the date, who assaulted Mr. Goodman, where it occurred, and then specifies that neither of them were employed at that location. So that seems pretty specific to me.
Your Honor, I don't think it says that neither of them were employed at that location. That would be factually incorrect. Certainly not. I think it's been admitted that...
Not at the 7-Eleven.
Oh, that is correct, Your Honor.
Yes. So I mean, to me, that seems pretty specific, so I'm not really following your argument on it being too general.
Well, there's not a reference to a specific paragraph in the complaint. There is the remainder of the complaint. Again, deposition transcripts were filed and a declaration from Mr. Goodman. And at worst, there's disputed issues of material fact here that were raised.
Why don't you focus on that for a minute and just refresh my recollection on what those are?
Absolutely, Your Honor. So, for example, there's a dispute as to whether the individuals, including Mr. Goodman and the assistant manager, were on the clock at the time the attack occurred. Mr. Goodman testified in his declaration that he did not recall clocking out and that he was directed or indicated by the assistant manager, one of the attackers, that he would go ahead and clock him out. Additionally, the corporate representative testified that despite receiving a preservation of evidence letter, the evidence concerning clock in and clock out times was destroyed. It was just lost. And so that would lead at trial, of course, to an adverse inference instruction, which would lead to an indication that Mr. Goodman was on the clock, which is what he said, and that the assistant manager was on the clock, and thus an instrumentality of Popeyes here, or Florida Pop LLC. So the point is well taken, but that's just one example. So it's not a premises liability case where the fact that it happened simply at the 7-Eleven next door is dispositive. This is a negligent hiring, negligent retention situation along with an assault and a battery here. And in negligent hiring and negligent retention, there is a specialized duty. Okay, so even at a motion to dismiss stage, for example, there is a special duty between an employer and an employee. And that duty specifically requires that the zone of interest be looked out for. And when the employer puts the employee in danger by, for example, not doing a thorough background check on an employee, then that employer is then responsible for harm that can occur. And that case is explored more fully in the Tallahassee furniture case in the initial brief.
Well, but that's a business and a customer. Wasn't that a furniture store that sent a delivery person to a customer's home and the delivery person assaulted the customer?
That is correct with respect to Tallahassee furniture, yes, Your
Right.
Honor.
So I see the special relationship there because you're a business that goes into customers' homes. You send your employee there. You better know who you're sending. But here you have two employees that get into an altercation outside of work. I'm not sure I'm understanding how that compares to the Tallahassee furniture.
Sure, and the reason Tallahassee furniture is brought to the court's attention is because it was not dispositive that the actions took place at the customer's home. The issue was not, was it on site, was it not on site, which is what the trial court referred to here.
Well,
That
it
was,
was in the course of his duties.
he was actually off the clock at that time, that employee in Tallahassee furniture. He was not on the clock, he went back on his own volition after he got off of work to the customer's home, where he proceeded to savagely beat her. So in this case, again, we have a situation where Mr. Goodman, who was an employee, it was not an altercation. Mr. Goodman left the premises, was told he would be clocked out, which again, there's a disputed issue of material fact here on that. And Mr. Green, the assistant manager, follows him to the 7-Eleven and pummels him. It's on video. Pummels him while Mr. Goodman is just standing at the register along with Mr. Lismore.
Let me just ask you, I want to just clarify, you keep referring to, you don't know if he was clocked out or not, but you're not arguing that he was still acting in the course and scope of his duties as an employee, right?
I am, to the extent that there's still an employment sort of tail going on here. He's still on the clock. He's still wearing his Popeyes uniform. There are factors here that could lead a reasonable jury to believe that this happened. For example, Mr. Goodman also put in his declaration, his sworn testimony, that it was not uncommon for individuals during the working hours to go next door to the 7-Eleven while on the clock, while on shift, and come back. In fact, that's what Mr. Green, the assistant manager, did in this case.
So what if he'd gone, he takes his break, he wants to go over to the 7-Eleven and get a big gulp, and then he beats the heck out of another customer in the store? So Popeyes would be responsible for that?
Absolutely not, because
Okay, then how is this different?
Because in this case, the reason for the altercation, or really the beating of Mr. Goodman, arose directly from the course and scope of the employment. In this case, Mr. Goodman was reporting Mr. Lismore for drinking on the job. He was reporting it up the chain through Mr. Green. And instead of taking preventative measures to protect Mr. Goodman, the Florida Pop people, the management, turned around and told Mr. Lismore what was going on, knowing that he had a history of burglary by sudden snatching, and knowing that he had been convicted of accessory to first-degree murder after the fact. So
So at what point would, and I'm sorry to interrupt you, but at what point would Popeyes no longer be responsible for what Mr. Lismore did with that information? What would the parameters of that be?
That is an interesting question, Your Honor. I would suggest that there is a difference between two employees, for example, who go out for a drink after work to the bar, and then they get into an argument over who's going to date the girl at the end of the bar, versus two employees, one of whom...
Okay, well, so, but you've laid that out nicely. So the employer gives Lismore this information, knowing his background, and because of that, you're saying that the employer is now liable for whatever Lismore does to Goodman. But there's got to be some boundary to that responsibility. So how would you define that boundary? Or would you say there is no boundary? Once they shared that information, all bets are off.
I would not say that, Your Honor. In fact, I would leave that to the jury to decide, because I would let the jury decide what the proximate cause is here. At some level, there is an endpoint. Where that is, I specifically can't say. What I can say is that the evidence showed, from what we submitted, that Mr. Lismore attacked Mr. Goodman a few short hours after being disciplined because Mr. Goodman had told management that Mr. Lismore was not doing his job again. So, you know, again, whether that few hours is the boundary or whether a week is the boundary, honestly, that's not for me to say, and I don't believe it's for the circuit court to say. I believe that's for the jury to determine.
You know, whether or not a duty is owed is a question of law.
Yes.
And that's what they hung their hat on, is that just under these circumstances, there is no duty. And so if we were going to say, well, yeah, there is, I mean, we would have to define what the parameters of that duty are. How would you suggest we do that?
Well, the good news is we don't have to, because the Florida Supreme Court has done that in a case called Malicki v. Doe, 814 Southern 2nd, 347 in 2002. And it talks about the torts alleged here, negligent hiring, negligent supervision. And it says the core predicate, at page 362, the core predicate for imposing liability is one of reasonable foreseeability, the cornerstone of our tort law. So again, the employer is liable when it hires somebody who they knew or should have known was a danger to themselves or others, really, others, and that employee does in fact act on that. So there is a duty imposed, there's a specialized duty in and of itself, and this is even cited in the footnote in the case relied upon by the defense counsel here, the public supermarkets case. It says there's a special relationship between the employer and the employee that already exists that creates a baseline duty, and then what the parameters of that are a conglomeration of factors. In fact, in Salerno v. Del Mar Financial Services, 248 Southern 3rd, 1186, out of the 4th DCA last year, the time, place, and circumstances under which the accident occurs are used here. They rely on scope of employment to address what the course of employment is. And in this case, we have an exhibit from the corporate representative where the workers' compensation carrier specifically indicated that Mr. Goodman was acting in the course and scope of his employment when this occurred. So to the extent we're going to look at admissions by party opponents, whether through adoption or so forth, that was presented by the plaintiff here. And again, I would suggest that we, as the plaintiff, do not have a burden unless and until the defendant, the movement, has met the extremely high burden for summary judgment. I mean, Florida Pop argues in the response that it was not obliged to present the circuit court with summary judgment evidence. That's what the respondent says, the appellee, in support of its motion for summary judgment. And it did not present any. The argument is contrary to the plain language of the rule and the rulings of this court and others. An order granting summary judgment without any summary judgment evidence cannot stand. Accordingly, Mr. Goodman respectfully asks that this court reverse the circuit court and remand for further proceedings, and I welcome more questions upon rebuttal. Thank you.
About 3 minutes. I let you go a little bit long.
Thank you, Your Honor.
All right.
May it please the court. Good morning again, Your Honors. My name is Tom Valdez, and I represent Florida Pop LLC, doing business as Popeyes Louisiana Kitchen. Your Honors, this is an unusually straightforward case. At the hearing in this case, first in the motion, which stated the grounds, it's the grounds on which it was based with particularity, and then at the hearing, where my colleague argued that with respect to the sequence of events and the discovery taken in this case, which proved the allegations regarding the sequence of events, that those things could only allow for a finding that Florida Pop had no duty, and obviously then breached no duty, to Mr. Goodman based on the facts of this case. Opposing counsel, well, let me get to that in a second. This argument led the trial court to state, it's true, based on my review of the amended complaint, and in parentheses, the evidence that's in the record, that there appears to be no dispute about the material, factual basis for this motion. And the trial court, in fact, said the only conflicts I find in the evidence are conflicts that were created by the plaintiff himself, Mr. Goodman. She said from the plaintiff's point of view, and based on his allegations, he had gotten off shift at Popeyes, that he had seen 3 men outside and had some degree of fear as a result of that, unelaborated, but that's what it said, that he had gotten his girlfriend to drive to Popeyes and pick him up because he was in fear of the 3 men that he saw in the area of the 7-Eleven. But then, according to his allegations, he and his girlfriend, despite the fear that he alleged, went to the 7-Eleven store. And I think that's really important because the opposing counsel focused on what people do of their own volition. Well, the plaintiff...
But we're here talking about whether the employer owed a duty to Mr. Goodman. It took information that Mr. Goodman provided them regarding Mr. Lismore, disciplined him, and then told Mr. Lismore where the information came from. You don't think that created some kind of special relationship?
Your Honor, it's unclear where exactly the information came from. Florida...
Maybe we shouldn't be on summary judgment.
Well, let me rephrase what I said there. The information did not come from Florida Pop. There is no evidence that Florida Pop, in its official acting in any kind of official capacity,
Is
told
there an allegation?
plaintiff.
Is there an allegation that it did?
Is there an allegation that they told this gentleman? Your Honor, I don't recall from looking at the complaint whether there may have been an allegation that he was told that he was being disciplined.
Did you conclusively establish that that was not correct?
Well, even if the gentleman was told, then still no duty arises, because if the gentleman was told you're being suspended, if we take that as true, he was told you're being suspended because you've been reported by Mr. Goodman, then certainly they would have to take reasonable steps to protect him, potentially, on the premises. I disagree with the notion that he had...
Protect him by not saying who reported him, but that's a different question. Anyway, go ahead.
It is, Your Honor. But what the evidence shows, what was agreed upon, and again, the trial court said that the only conflicts that she found were in the plaintiff's version of the events here. The question is, now this gentleman was sent home. He was told to leave for the day, was suspended. At that point, my client had no reason to believe that he was going to come back to the premises and cause any harm to this individual. There's been this...
I think they're alleging your client knew or should have known that.
They do claim that, Your Honor, but the material facts are undisputed in that this gentleman...
Well, we actually don't have facts. We just have the allegations of their complaint, which you've accepted as true.
Well, but then there was additional evidence added into the record by the plaintiff, as the court pointed out, and honestly, they didn't do themselves any favors with that evidence, because what that evidence shows is that Popeyes did not know when this gentleman was hired that he had a prior criminal history. That subsequent to that, they found out about a prior criminal history, and that the prior criminal history that they found out about was that he was an accessory after the fact to a murder. He had not committed any violent act himself at that point in time. And the case law that talks about this, and the case law that we cited, is pretty clear that a prior criminal history, first of all, that criminal background checks are not required in all cases, certainly where someone's applying to be a fry cook.
Yeah, but that's not the issue, because they knew. right? You just said they knew.
I said
They knew
that,
his background.
I said that, to be clear, they did not know at the time that
but
he
they
was hired.
eventually knew.
But they eventually found out about this crime that did not involve violence, which is an important point. In any case, and shifting back to the argument, the trial court mentions that an affidavit, and opposing counsel continues to reference an affidavit or something of the sort. I didn't see anything like that in the record, and I'm a little bit new to the game, so maybe I missed it. But the trial court says that that really didn't help them, and the trial court says that this idea that he didn't clock himself out has nothing to do with the concept of duty. It's really more of a red herring argument. What the evidence supports, and that the only conclusion that can be reached as a matter of law, based on these allegations that are admitted in the evidence, are that Mr. Goodman left the Popeyes premises, that he was off duty, that Mr. Lisbon was off duty, had returned to the premises.
The statement she made that the workers' compensation carrier considered this to be an on-the-job injury?
That's an interesting statement. What you'll see if you take a look at the deposition of the corporate representative is that there's an email attached there where the carrier in an email makes a comment to the effect that she believes this might be covered. But if you continue to read on through that deposition, you see that the workers' comp carrier, the carrier that lady worked for, eventually said, there is no coverage here. So Popeye shouldn't be penalized for trying to get coverage for Mr. Goodman based on the workers' comp policy, coverage that was ultimately denied. But what you asked about where the boundaries stop, and where the boundaries of duty stop are really discussed in great detail in the case that my colleague relied on below, KM versus Public Supermarkets. And before I get into kind of the meat of that case, I would point out that the court said in that case, to address one of the plaintiff's arguments, that the occurrence of an assault off the premises took that case out of the realm of negligent hiring, retention, supervision, in an action it took that case out of and precluded an action against Publix for negligent hiring, retention, and supervision. I think that's a key point in that case, which also recognizes the Florida Supreme Court case that opposing counsel cited. So this is, I think, based on the Publix case, that this is out of that realm. But what we find based on the Publix case is there was an employer-employee relationship here, but as the Fourth ECA explained in KM versus Publix, the special relationship test is a limitation on the scope of the defendant's liability for the intentional acts of third parties. It's saying that there has to be, as Your Honor pointed out a little earlier, there has to be a limitation here. We can't let duty carry out forever. And the Fourth ECA in that case cited to this court's decision in Garcia versus Duffy from back in 2006, where it said that once liability began to be imposed on employers for the acts of their employees outside the scope of their employment, the courts were faced with the necessity of finding some rational basis for limiting the boundaries of that. And that's what the court did in the Publix case. And it said that otherwise, an employer would be an absolute guarantor and strictly liable for any acts committed by its employee against any person under any circumstance.
But isn't Publix distinguishable? Because the relationship that arose out of was a purely personal relationship between the two employees who happened to meet because they were both employees of Publix. The one was babysitting the other's child. That's purely personal. What we have here is different because basically we have an act in retaliation for the complaint that Mr. Goodman made to Florida POP regarding Liz Moore's performance.
That's certainly a factual difference between the Publix case and this case, but I don't think it's dispositive.
Isn't that significant? Because one arose out of something that was clearly within the course of their employment. he's drinking on the job, you need to take action against him, and then he gets beat up for it. Isn't that different from just a personal relationship and, when a child's assaulted during babysitting?
Your Honor, I don't think it is at all. When you look at all of the facts in detail, in the Publix case, Publix knew that this individual was a convicted child molester and was found to have no duty to tell its one employee that the other employee was a child molester. And so, off its premises, that individual harmed yet another party, the child of its employee. He wasn't acting for Publix. He wasn't acting in the scope of employment. He wasn't acting on Publix premises. He wasn't using any of Publix's instrumentality. That's exactly the case that we have here.
Well, and to sort of flip it around, wasn't Goodman acting in the course of his employment with Florida POP when he reported Liz Moore for drinking on the job?
He was, and Florida Pop responded appropriately by suspending that individual. But at that point, they had no notice that there was going to be a physical altercation between the two. And when you look at the allegations of the complaint that plaintiff does not disagree with, they're the ones that I talked to you about before. He had ended his shift. Though he claimed that he was in fear because he had seen 3 gentlemen on the 7-Eleven premises, he went on to the 7-Eleven premises anyway. I mean, he said that he has so much fear that instead of riding his bike home as he usually did.
But to me, that's a distraction. I'm sorry. How does that? Let me just put it a different way. Tie that into how that impacts whether or not the employer had a duty here.
Well, Your Honor, that breaks that's certainly, you talked about limitations, and Popeyes clearly has a duty to protect him while he's on the premises. It clearly does not have a duty to protect him if they're at a party 5 miles away and they get into a dispute. The question that this case presented as a matter of law was, did they have a duty to protect him while he was on the 7-Eleven premises, a place where he had gone of his own volition? That breaks the chain of duty there, where he is admitting that although he was...
So if this happened in the Popeyes parking lot, you'd have a different position?
If this happened in the Popeyes parking lot, we might have some different arguments to make, because I think there would be a different standard. The Publix case would not be as strong for us if it had happened on Popeyes premises during work hours, utilizing Popeyes instrumentalities. But this happened at the 7-Eleven that was a little bit removed from Popeyes. It could as well have happened at a 7-Eleven on the other side of town. It's a place that this gentleman chose to go and happened to come into contact with these individuals who are not acting in the course and scope of their employment or in any way on behalf of Florida Pop.
Their argument, and when she gets up for rebuttal, she can correct me if I'm wrong, but I think their argument, the big picture is the employer, Popeyes, and just forget they're even an employer for the moment. Popeyes did something that put this man in harm's way, and they're responsible. They had a duty to not do that.
Well, Your Honor, I think without looking back at the complaint, I think the allegation was that this gentleman, Mr. Goodwin, was told. He was told, to the extent he was told by anyone, it wasn't anyone that was acting within, there's no evidence that it was anyone acting within the course and scope of their employment with Popeyes. There's no evidence of that. There are some claims that this gentleman told his employers at Popeyes, hey, there are 3 men outside, and at 7-Eleven, and I'm so concerned, I'm going to call my girlfriend to come pick me up. Now, that's a point at which a duty could potentially have arisen, but he tells them, here's what's happened, I'm concerned, I'm going to take steps to avoid the problem. But then, as the trial court herself noted, the only conflict in the evidence here is he goes directly into the face of what he claims that is the danger, what he claims is the fear, off Popeyes premises, off or away from anywhere that the people that he's spoken to, his managers, can protect him, and that's where this incident happened. And based on the public's case and based on what Your Honor pointed out earlier, at some point, the duty has to end. And where there's action by a third-party criminal action that's not on behalf of the employer, that doesn't happen on the employer's premises, that doesn't involve any instrumentality, that doesn't or involve anyone acting in the course and scope of their employment with Popeyes, there just isn't any duty here. For that reason, the trial court got this right, and this court should affirm the entry of final summary judgment in favor of my client. Thank you.
May it please the Court, Your Honors, I would like to address directly what was said by opposing counsel, looking solely at the amended complaint because that appears where we are. I'm looking at, and this is record page 309, paragraphs 38 and 39. Green came back into the store and told Goodman that although Robertson, who was the manager, was originally opposed to suspending Lismore for his conduct, Green had pushed for the suspension, and Robertson had finally agreed to suspend him. So again, Mr. Lismore could have been fired, suspended, but instead it was a lesser action. Paragraph 39, Robertson then said something to Goodman to the effect of, although he had protected Goodman from Lismore in the past, he didn't know if he could anymore. Goes on to paragraph 48, Lismore asked Goodman why he snitched on him during the attack. Furthermore, it's in paragraph 80, which is at record page 314. Specifically, instead of keeping Goodman's reports about Lismore's behavior, such as drinking on the job, confidential, the company, by and through its management team, informed Lismore of Goodman's reports. Paragraph 81, furthermore, on the evening of the attack, Goodman returned to the inside of the company's building and told the managers on duty, including Green, that he did not feel safe. 82, the company did not take any protective action for Goodman. Paragraph 83, to the contrary, individuals who worked at the location where Goodman worked for the company were aware that there was a plot to jump Goodman in play, a plan that Lismore actively took place in. Paragraph 99, Green was acting within the real or apparent scope of his employment with the company. These are allegations that were there. Additionally, I would like to point out the differences that were discussed in the public's case need not be readdressed by this court because it was discussed at length in the case of TW v. Regal Trace, 908 Southern 2nd, 499, stating, however, it should be noted there was no special relationship in the public's case between the employer and the injured child. It had to do with the employer to the child, not the employer to the employee, as we have in this case, because a grocery store is not in the business of arranging for babysitters. And because a duty existed as a matter of law, the court went on, it is for a jury to decide whether Regal Trace breached that duty. In that case, as in this one, there was no evidence, this case there is no evidence to support that there was summary judgment worthy materials. And to quote opposing counsel, a duty could not have arisen if Mr. Goodman had sought help. He did seek help. He did. And one of his attackers said, I'll clock you out, go ahead, effectively. And then proceeded to follow him to the 7-Eleven and pummel him on camera. Your Honors, I thank you for your time, and I sincerely hope that this case is reversed and remanded for trial court consistent with the case law presented. Thank you.
Thank you. Thank you both.